All right. All right, thank you. We're just waiting for the defense. What's Sean? All right, do I need to sign up for the walk? I just got this email. Yes. Okay, so I just sign up?
Yes.
Okay.
There's no donation.
So do we already have a team with you?
All that, I didn't make a team, the team on there is fine, or you don't have to sign up for a specific team.
Okay. All right, I'm putting it in the calendar. Michelle, I'm gonna do what my grandmother did. Things, I don't like them. So maybe my taste buds off. You'll have to tell me. No one eats licorice.
I Judge, the family is on their way. They were across the street. So
All right, no problem. We will wait.
thank you, Judge.
Oh, yeah. No, we never keep her.
Oh, we can do that too. Look here. It'll be the cute community licorice now.
Like, say she's training somebody, and then once she's good, then they'll move her, and then there's just a train.
Sean, that walk, is it a 5K, the suicide watch walk? Because it doesn't say. Because you know what, I have a 5K in me, but if it's going past 5K, I don't know.
It's fine.
Okay. All right. But you know what my brother said? Because when I told him, I said, I know I have a 5K in me. Then everybody started telling me, Stephanie, 5K can sneak up on you. So, but I know I have a 5K in me.
It's not a bad walk at all.
Okay.
It's
Yes. Oh, just 1 second, I'm sorry. You want to call your counsel and, the door is opening now. All right, so everyone, court has been informed that there's a verdict that has been reached. Here's the thing. There is not to be any outbursts. Either way, there's no cause for celebration. There will not be any celebration. There will not be any cheers. There will not be any laughter. Does everyone understand? And let me repeat myself because other people are walking in. Oh, please have a seat. All right. To the people who have just arrived, I've just explained to everybody, there's a verdict. There will not be any celebration from either side. There will not be any laughter. There will not be any hand gestures. If any of that happens, you will be asked to leave the courtroom. Does everyone understand? All right. I know a lot of people always assume that the court knows what the verdict is, but I do not. So we will find out together. All right. Court is going to call. Oh, we have more people coming in. Let me repeat myself. All right. There's a verdict. There's not to be any celebrations. There's not to be any hand gestures. There's not to be mumbling of any under anyone's breath. Does everyone understand? If a deputy taps you on the shoulder, that means that you are to leave the courtroom. There's to be no argument. Does everyone understand? All right, court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Raymond Salanya,
Daniel Rosengard.
Defense?
John Floyd for the defense, Your Honor.
Chris Choate, Your Honor.
And are you Mr. Robbins?
Yes, ma'am.
All right, let's bring the jurors in.
All rise for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is your verdict unanimous? All right, if you'll pass the document to the deputy, please. All right, count one. Jury finds the defendant not guilty. Count one, the lesser included offense. Jury finds the defendant guilty. Count two, the jury finds the defendant guilty. Count three, the jury finds the defendant guilty. Does anyone wish to have the jury polled? State,
Not from the state.
defense?
No, Your Honor.
All right, so ladies and gentlemen, I'm going to have you step in the back for 10 minutes and then I'll bring you back. All right, everyone, please rise for the jurors. All right, defense, do you have witnesses?
We might have one as well, Judge.
All right, how much time does each party need before I bring the jury back in?
10 minutes or so? Agreed.
All right.
Sorry.
All right, so counsels, since he's been found guilty of counts 2 and counts 3, they're just gonna put the leg brace on and then they'll bring him back out.
Is it just 2 and 3 or is it?
Oh, I'm sorry. He's guilty of the lesser included from count 1 and then guilty of counts 2 and counts 3. Okay, all right. All right, thank you.
Just follow mom, but that's not sure at first. I'm showing you the bathroom.
Counsel, they'll bring him back out and I'll give you all an opportunity to speak to him. All right. And if y'all need to speak to him in private,
Yes. For a few minutes.
okay. It usually takes about 10 minutes
Okay,
for that.
it won't take long, Judge.
Oh, no, take as long as you need.
Okay, thank you. Yeah. Am I gonna take anything? I just want to I'll take a pass.
Oh. If y'all want to talk to him in here, you can talk to him in here and I'll have everyone wait outside except for the deputies. Okay. All right.
Thank you, Ted.
You're welcome. Yes. There's no amount on this.
Yeah, they emailed it directly to her. She just wants this form to get attached.
Okay. Are y'all ready to bring him out?
They have, so we have to get.
Sure. Okay, thank you. Counsel.
Yes, sir. If you wanna come over here, you all go to the courtroom next door. Yes.
Oh, excuse me. Is he able to go that way? You can go through that door.
Okay, thank you, Judge.
Thank you. Welcome. Oh, you can line them up. Yes. All right, are both parties ready to proceed?
Your Honor, before we proceed, State would like to make an oral motion to stack the sentence on each count. The state is ready to proceed.
They made their motion. I haven't ruled on their motion. So I don't know if you all were prepared for that or not.
I mean, of course, we would argue against it, Your Honor, given the circumstances of the case. This is really all one continuing course of conduct. Given all the circumstances around it, we would argue against the motion to stack.
All right, are both parties ready to proceed?
State's ready to proceed.
Yes, Your Honor.
All right. All right, you can bring them in. Yes.
All rise for the jury.
All right, everyone, please be seated. State, do you have opening statements?
Briefly, Judge. Ladies and gentlemen of the jury, we thank you for the verdict. Thank you for reviewing the evidence and coming with a unanimous decision in this case. The defendant was elected. If you 12 sentence in this case, and as you all know, pre-jury selection, the judge did mention that in Texas we have two systems. We have the guilt innocence phase. This is the sentencing phase. I will be calling mom to testify, so we can talk to you a little bit about the impact that this has had. At the end, we'll be giving you a closing recommendation as to what I think is the appropriate sentence in this case, seeking guidance, but ultimately the decision will be resting with you.
Defense.
Thank you, Your Honor. Ladies and gentlemen, always difficult from the defense to come back after something like this. What I do want to tell you is that we appreciate all the time you put into the case, the consideration, and after the stage is rested, we'll have an opportunity to talk to you and what you're going to make your recommendation. Thank you for your time.
All right, state, call your first witness.
State calls Alexander Reed.
All right, if you'll take a seat here, please. All right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, and if you'll restate your name for the record.
Alexandra Reed.
All right, state.
Thank you, Judge. And at this time, the state moves to enter the evidence from the guilt innocent phase into the sentencing phase.
All right, with defense's previous objections to the evidence.
Yes, Your Honor.
All right. Then evidence will be admitted along with defense's previous objections. You may proceed.
Thank you, Judge. Alexander, I want to talk about Arabella. You have, ever since February of 2022, can you please tell us the impact that this has had on her?
Once she shared with me what her father was doing to her, she was terrified. She would have nightmares. And I mean, you could hear just the struggle she was having in bed, where she was waking up with just dark eyes because she wasn't getting rest, going to school, having panic attacks because he would pick her up from that school. And she thought he was gonna come, pick her up, take her back to his house and hurt her, or kill her, or come to our house because we lived down the street and shoot us, kill me, my husband, her brother, her sister, and then take her and hurt her or kill her
And this was coming directly from Arabella.
from Arabella.
Was this when you started counseling with Miss Bernstein?
Yes.
So did the effects increase or did they get any better? What was the effect that counseling had on Arabella at the very beginning?
At the very beginning, it was good, but because we'd have to go to Child Safe and Center of Miracles, which we had to wait for those appointments because sadly it was all booked up until the days that were open. And she couldn't just tell and try to forget or try to automatically heal. She knew that she had to hold on to them and had to share them with more people. And every time she would, we'd be out and she would have a memory. It could have been a place, Chick-fil-A, or a shirt that looked like something that her dad would have or something that would trigger her to a memory with him. And then it would instant be panic attack or just zoning out where no 7-year-old should endure. No,
Did did the Miss Bernstein or did anyone ever recommend that she express her feelings a certain way?
journaling, drawing the bad memory out, and then writing the good from the day, God's promises that she was safe, that she didn't have to see him, and that there was still blessings happening around her. That yes, the bad things happened, but she had people around her that was going to protect her.
These journals, journaling, did she have any specific journals that she kept?
She did.
How many journals did she have?
I believe she had 2 possibly.
Did you ever get to see what was in those journals?
I did. She did share some of her drawings.
So what kind of things did you see when you were going through her journals?
Drawings of Jordan and with a mad face, with a gun in his hand, and her crying in the picture and it's saying kill, kill, kill.
Were those images common or were they just sporadic?
When she first outcried, it was, twice a week, maybe. It was pretty frequent. It was very difficult for her with the panic attacks, the nightmares, the triggers.
Did Arabella ever get referred over to a psychiatrist?
Yes, she did.
At some point, it's my understanding that there was a dog involved, correct?
Yes.
Can you please tell us a little bit about that?
So the psychiatrist diagnosed Arabella with PTSD and panic disorder and wanted to prescribe her on medication. And I had spoke with Dr. Stafford about the medication, and we discussed a service dog instead of starting her on this medication that could be very addictive starting at such a young age. So we found our dog, the puppy, and Joy, that's what she named her, really helped her at night with nightmares. She would just cuddle up on her, and she really helped her with that.
In preparation for this criminal trial, you mentioned that you came to the district attorney's office with other prosecutors as the case was getting closer to trial. What was going on through, if you know, through Arabella's mind every time the case kept getting set for trial?
She didn't understand when it wouldn't go, when she shared, I don't understand. I told them everything. Why is it taking so long? Because again, she knew she had to remember, but she didn't want to. And that was the thing, is she was trying so hard to forget everything, and just kept saying she just wanted to be a kid. She just wanted to play with her brothers and sisters, to play with her friends, to go do things she loved and not have to hold this.
Ever since she started therapy, has she made progress?
She has made progress. She knew she still had to come to the stand and do this, but she was being a kid as much as she could.
Did this have any effect on her in school?
It did. She would have to go to her counseling sessions, and then the panic attacks at school. Her teachers would have to move her closer to their desks to make her feel safe, because every time someone would just come into the classroom, she would think it was her dad coming, or she couldn't be by a window because she thought he was going to shoot the window and come through the window, where her principal had to show her around the school where it was a gated school, that couldn't happen to her, that wasn't going to happen. But it was just affecting her so much that I pulled her out and I began homeschooling her.
When did you pull her out? How old was she when you pulled her out?
I believe it's in the 3rd grade. I believe it was right after she turned 8. Or I guess she was, I believe it was the 3rd grade when I pulled her out of school.
Tell us a little bit about her home life. How is she doing at home?
She's doing good in the sense that we can help her when she feels like she's having a bad day in memories, or cheer her up with, you know what, let's go to the park today, or let's do school at the library today, Or let's do these things when we've seen, okay, we didn't have a good night. Or she had a bad memory. And even with the homeschool where there's things she struggles with, we can do one-on-one on really encouraging and helping her with those issues or the problems.
Is there anything in particular that you would like the jury to know about Arabella, about the effect that this case has had on Arabella that you have not mentioned already?
So everything to get up here on the stand and tell you her truth. And she's proud of herself for being able to do that. She's a kid who didn't understand why her dad was doing this to her. She didn't understand if this was his expression of love.
At this time, we pass the witness.
All right, defense.
I have no questions for this witness, Your Honor.
All right, you may step down. State, call your next witness.
The state has no more witnesses.
All right, defense, any witnesses?
No, Your Honor.
All right, ladies and gentlemen, I'm going to have you all go back to the jury room, and I will bring you all back in approximately 15 minutes. All right, everyone, please rise for the jurors. Right, everyone, please be seated. All right, so the state, and we can be off the record, the state is asking that the counts be stacked. The court will hear argument from both sides on that, if the jury is able to reach a verdict with regards to sentencing. So I won't take that up now. I'll give you all both a chance to formulate your arguments.
Thank you, Judge.
All right, so what I'm going to do is I'm going to print out the charge and see if anyone has any objections. All right, thank you so much. All right, so everyone, the printer is dead.
Uh-oh.
So I'm gonna see if I can have someone else print this out for everyone. We're ready? Yes.
All rise for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you the charge of the court on punishment. Again, you do not need to memorize it. You will have the original with you when you begin your deliberations. Members of the jury, by your verdict returned in count one, you have found the defendant, Jordan Robbins, guilty of the lesser included offense of indecency with a child by sexual contact. By your verdict returned in count two, you have found the defendant, Jordan Robbins, guilty of the offense of indecency with a child by sexual contact. By your verdict returned in count three, you have found the defendant, Jordan Robbins, guilty of the offense of indecency with a child by sexual contact. It is necessary for the jury to assess the punishment for these offenses. You are instructed that the punishment for the offense of decency with a child by sexual contact is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not less than 2 years or more than 20 years. Therefore, you will assess the punishment of the defendant for a term of not more than 20 years or less than 2 years in each count. In addition to imprisonment, an individual found guilty of the offense of indecency with a child by sexual contact may be punished by a fine not to exceed $10,000 in each count. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in each verdict. If you assess a fine, it is not paid to the victim or victims, if any, but is paid into the registry of the court. When there are separate punishments on multiple counts, whether those sentences run concurrently or consecutively, that is, at the same time or one after another, is a decision to be made by the court. If there is any evidence before you that the defendant may have previously committed offenses or acts of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe, beyond a reasonable doubt, that the defendant committed such other offense or act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such offense or act of misconduct was committed, or as to whether the defendant was involved in such other offense or act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot be accurately predicted how the parole law might be applied to this defendant because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bear County, Texas, and suitable forms are attached. State, are you ready to proceed?
The civil reserve its time, Judge.
All right, defense.
Thank you, Your Honor. Um, What I also want to do is just, first of all, start off by repeating what I said earlier. Um, These cases are very difficult. They're obviously very difficult for everyone involved. And while we may disagree with the judgment as far as guilt or innocence goes, we understand it was a hard decision and we respect it. Because you guys sat here, you heard all the evidence, you took a lot of time to consider it. And we do respect your time and your attention. One of the things I want to just kind of point your attention to, because there's a paragraph at the end here that talks about other acts of misconduct. And so the only thing we really have outstanding that I would like to point out is what Ms. Reed testified to. There was testimony about her child feeling scared that the defendant might harm her, they might kill her, they might shoot her, about drawing pictures of firearms. One of the things this paragraph tells you to do is you should not use that unless you believe those allegations will prove beyond a reasonable doubt. I don't think that she was testifying that he did those things, but I just want to make sure that it's clear that if these were just reactions the child was having, that those are not offenses that have been, there's been no proof, no evidence submitted to you to prove that allegation beyond a reasonable doubt. I think it is just a reaction to the trauma the mom was testifying to. So you heard, and honestly, you heard from all the witnesses we would have called at sentencing trial. You heard from Miss Tammy Robbins, you heard from Miss Josefina Obregon, and you also heard from the defendant. Other than the offenses, which you have now convicted him and found him guilty of, it appears that otherwise, Mr. Jordan lived a good life by any accounts. He worked hard, put himself through college. He has a family that supports him and is behind him. He did everything he could from a financial standpoint to take care of his child. I think there's no doubt that you saw when she walked into the courtroom, he still loves his child. Regardless of what you have found him guilty of, I think it's important that you consider him for who he is and his background. There's no evidence whatsoever that he has any kind of criminal history. There's no evidence whatsoever that he has any kind of drug or alcohol issues. There's no evidence whatsoever he had any problems while he's been on bond while this case has been pursued. He will now be a convicted sex offender for the remainder of his life. And so whatever happens here today, that is something that he will have to deal with for the rest of his life. The range of punishment, as the judge said earlier, is anywhere from 2 to 20 years on each count. And so when you go back and deliberate, we would ask that you consider the very low range of punishment, which would be 2 years in this penitentiary. We'd ask that you assess no fine. And that doesn't go to the victim, it goes to the court system. And you would just consider all the evidence that you heard when we were presenting our case. No matter what we've heard today, I don't believe that Mr. Jordan Robbins is a threat to the community. He will not be a threat to Arabella anymore. We just ask you to consider no more than 2 years. It's something that is fair, and reasonable. It instills a respect for the law. It punishes Mr. Robbins, but it's no more than necessary. Thank you.
Dave?
Thank you, Judge. Ladies and gentlemen, of the jury, the consent hearing exam. Sounds up to be not easy. Each one of you like this. What I can do is I can provide you some factors to take into account. The starting point that I would recommend would be starting in the middle of it. And depending on mitigating, or depending on the factors I'm gonna give you, you can go down or you can go up. If we start at 10, which is, well, if we start at 10, it's not necessarily the middle ground, but if we start at 10 years, I like to point out to you 3 things. One is the times, the number of times committed. Number 2 is the age of the complainant. And number 3 is the effect this is having. So we go with the factors. We start with the multiple, with the instances that happen multiple. It happens in 2 different places. Arabella gave you details as to what he would do. But because it happened so often, she didn't tell you how many times. She just said it happened multiple times. And she knows that it happened multiple times because they were alone in the house. So there's times when Josephine was there, there were times when she was not. Her age is not talking, not to take away from a victim that may be 13, 14, or 15, but we're talking about a child that is between 5, 7. You heard Alexandra testify. She's a child. She just wanted to be a kid and play. She didn't understand why this case was still open. She just wanted to get it over with. She didn't want to talk about these things. She didn't understand why her dad was just not in trouble. She didn't know any of this stuff. I think the fact that her age is just so young, that is an aggravating factor that needs to be considered. The innocence of her going through this is important to consider. And lastly, unfortunately, the effect that this has had on her. Mom talked about the trauma that she's got throughout. It has affected her at home. She's scared of the defendant. She's mad that he's going. She's scared that he's going to take her away and he's mad at her. She couldn't sleep, so they have to get a service dog to stay in her room with her so she can feel safe. As a person, she was diagnosed with PTSD. And she was also diagnosed with panic disorder because she is scared. She used a journal. A journal where she's writing her feelings, her bad feelings, because it's helpful to therapy. And the effect that she has had in school. She had to be moved closer to the teacher. When she was in school, the principal had to show her, look, you're safe. There's no danger. Mom had to provide homeschool. Those are important factors that we need to take into consideration in this instance. The fact that it happened not just once, it happened multiple times. We just alleged 3 different instances, but that happened multiple times. The age and the effect. For those reasons, I believe that you should sentence Ms. Robbins to 15 years in each count. 15 years for the damage, for the harm that he has caused to Arabella. She has been doing better, but this kind of trauma, you don't know that. You just learn to live with it. So for most recent states, gentlemen, I've sentenced Ms. Robbins. Years. In prison, I'm not asking for fine. The fine is not going to be good, so it's safe. It's 1, 2, 3.
All right, ladies and gentlemen, both parties have presented their closing arguments to you. I'm going to send you back to the jury room to deliberate. Again, the two alternates, the deputy will place you in a separate room. All right, everyone, please rise for the jurors. All right, everyone, please be seated.